I want to tell you about a case that came before me recently. Before I do, I need to set something down. I set my glasses on the desk when I am about to say something that requires my full attention. Not as a gesture, not for effect. It is simply what I do when I need the room to understand that what follows is not procedural, that what follows is something I have thought about carefully, and that I am about to be accountable for every word of it. I did it that morning in my courtroom. I am doing it now. I have been on this bench for 4 years. I have presided over drug trafficking cases, wire fraud cases, cases involving civil rights violations that made people in the gallery quietly cry. I have sentenced people who did terrible things to other people, and I have done it without flinching, because that is what the oath requires. And in 4 years, I have had exactly one case where I had to stop, remove my glasses, set them on the bench in front of me, and ask the courtroom for a moment before I continued. This was that case. A 75-year-old pastor arrested for giving away soup. I want you to sit with that for a moment before I tell you anything else. Not the ordinance, not the city's argument, not the constitutional question I was ultimately going to have to answer. Just that sentence. A 75-year-old pastor, 11 years of Saturday mornings, a folding table, a pot of soup, 12 or 15 people on a sidewalk who were hungry, arrested, brought before a federal court, charged under a municipal permitting ordinance. That is the case I am going to tell you about. Not the principle behind it, the case itself, the man, the room, what I observed, what I decided, and what it required of me to decide it correctly. His name, and I am going to use it because using it is the least this case requires, was Reverend Leonard. He walked into my courtroom that morning wearing a dark suit that had been pressed carefully. Not a new suit, a cared-for suit. The kind of suit that tells you something specific about the person wearing it, that they understood the gravity of where they were, and that they had prepared themselves for it without anyone telling them to. He was 75 years old. He walked without assistance. He sat at the defense table and folded his hands, and he looked at me the way people look at someone they are prepared to trust. Not blindly, but because they have decided that trust is the appropriate posture for what they are about to face. The city's attorney was already seated when Reverend Leonard arrived. She was perhaps 40, well prepared, carrying a file that I could see from the bench was organized with the specific neatness of someone who had done this kind of proceeding many times and found it routine. She did not look at Reverend Leonard when he entered. She was reviewing her notes. I noticed this. I notice everything in my courtroom because everything in my courtroom is information. Not always legal information, but always information about the humans in the room and what they understand about where they are. What the city's attorney appeared to understand was that she was in a routine permitting enforcement proceeding. What I needed to determine was whether she was right. She was not right. On the evidence table, entered by the prosecution as their primary exhibit, was a photograph. I want to describe this photograph to you carefully because it is important. It was a color photograph taken from the sidewalk showing a folding table set up on a public walkway. On the table, a large pot, a stack of styrofoam cups, a plastic container of crackers. Behind the table, a man, Reverend Leonard, in a jacket, ladling soup into a cup held by a woman in a gray coat. In line behind her, 11 other people. The photograph was crisp, well lit, taken on what appeared to be a cold morning. The sky behind the group was white. The prosecution had entered this photograph to demonstrate the violation, to show what had occurred without a permit, to make the case that the law had been broken. I looked at that photograph for a long time. I want to be honest about this. I looked at it longer than I needed to look at it for legal purposes. What I was looking at was 12 people who had been hungry and were not, because a 75-year-old man had set up a folding table on a Saturday morning and brought soup. That is what the photograph showed. That is what the prosecution had entered as evidence of wrongdoing. I have been a federal public defender. I spent 5 years sitting across a table from people who were about to learn what a judge's decision was going to mean for the next decade of their lives. I know what it looks like when someone uses the legal machinery of this country as a weapon against people who cannot adequately defend themselves against it. I recognize what I was looking at. The question before me was not whether I recognized it. The question was what the law required me to do about it. I want to tell you what the ordinance actually said and what it was actually for, because the distance between those two things is the entire case. The ordinance, passed by the city council 18 months before Reverend Leonard's arrest, required individuals and organizations to obtain a permit before conducting what it called organized distribution of food in public spaces. On its face, this was presented to the public as a sanitation and public safety measure. The city's argument from the beginning was that unregulated food distribution posed health risks and created disorder in public areas. The attorney would cite these justifications 3 separate times in the course of the morning. Each time, I let her finish. I had read the legislative record for this ordinance before the proceeding began. I do this with every case that involves a statutory question. I read not just the law, but the history of the law, because laws do not appear from nothing. They are written by people, proposed for reasons, debated in rooms, and passed under pressures that the final text does not always reveal. The legislative record for this ordinance was available. I had read it. What the record showed was this. The ordinance had been proposed in direct response to a formal letter submitted to the city council by a neighborhood business association. The letter expressed concern about the presence of homeless individuals near the association's member storefronts. It referenced specifically the Saturday morning distributions that Reverend Leonard had been conducting for 7 years at that point. It asked the city to address what it called the ongoing impact on the commercial character of the neighborhood. 3 weeks after that letter was submitted, the ordinance was introduced. 8 weeks after that, it was passed. 6 months after that, Reverend Leonard's permit, which he had held without incident for 7 years, was revoked. He was informed by letter that the revocation was for administrative reasons, with no further explanation. He continued distributing soup the following Saturday, and the Saturday after that, and for the 11 months between the permit revocation and his arrest. I want you to hold all of that in mind when I tell you what happened next. I asked the city's attorney in the opening phase of the proceeding to address something for me. I asked her, in the city's view, what legitimate public interest was served by the permit requirement as applied to the conduct in this case, not as applied to food distribution generally, as applied to this man, this table, this Saturday morning. She said the ordinance was designed to ensure sanitation and public safety in public spaces, and compliance with it was necessary for consistent enforcement. I said, I understand the stated purpose of the ordinance. I am asking about its application. What specific public safety or sanitation risk was addressed by requiring a permit for this particular activity in this particular location, conducted in this particular manner? She consulted her notes. She said the ordinance applied uniformly and selective application would undermine its enforceability. I asked the question a third time. I want to be precise about why I asked it 3 times. Not to embarrass her, but because the answer to that question was the legal fulcrum of the entire proceeding, and I needed the record to reflect that the city had been given every opportunity to provide it. The third time I asked, the city's attorney said that the city had applied the ordinance in accordance with its terms, and that the question of whether it served a legitimate interest was properly addressed to the legislative body that passed it. She was not wrong about the law in the abstract. Legislative intent is, as a general matter, reviewed with deference. But the specific question of whether a facially neutral law is being applied in a manner that violates the constitutional rights of the person before the court, that question belongs to me. That is precisely what it belongs to me. I noted her answer for the record. I thanked her. I moved to the next phase of the proceeding. Reverend Leonard's attorney had filed a motion challenging the ordinance as applied to his client's conduct. It was a well-constructed filing. I had read it 3 times. The argument was straightforward and, in my assessment, correct. The First Amendment does not permit the government to use a facially neutral regulatory scheme to accomplish what it cannot do directly, which is to suppress expressive conduct, including charitable religious practice, because the neighbors object to the presence of the people it serves. I want to be honest about something. That is a legal argument. It is a correct legal argument. But the reason I had read the filing 3 times was not to satisfy myself that the legal argument was sound. It was to satisfy myself that I had not missed anything that would require me to rule differently. I had not missed anything. The argument was sound, the record supported it, and the constitutional question was not, in the end, particularly close. What was harder, and I want to be precise about what I mean by harder, because it is not the same thing as more difficult legally, was sitting in that courtroom with the full awareness of what the proceeding itself had cost the man seated at the defense table. Not financially, not professionally. The cost of being 75 years old and having done something decent for 11 years and then being arrested for it. The cost of walking into a federal courtroom in your best suit and having to prove that what you were doing, feeding hungry people, was not a crime. That cost is not addressed by the legal ruling. The ruling cannot give back the Saturday morning when the officers came. It cannot restore the specific quality of the years before the permit was revoked, when what Reverend Leonard was doing existed in the world without legal complication, because it was simply a man and a table and soup and people who needed it. Those years were not undone. They were real. But the shadow that had been placed over them, the official suggestion that they were a violation, that they were something the law needed to address, that I could address, that was mine to address. I denied the city's motion to proceed on the primary charge. I want to read you from memory the essential finding. I said the ordinance, as applied to the defendant's conduct, fails constitutional scrutiny. The record before this court establishes that the ordinance was proposed and adopted in direct response to complaints from commercial interests about the presence of homeless individuals near their properties. The permit revocation was not accompanied by any explanation referencing public safety or sanitation. The defendant's conduct, the private charitable distribution of food to individuals experiencing homelessness, constitutes expressive activity protected by the First Amendment, and, to the extent it reflects the exercise of religious practice, by the First Amendment's free exercise clause as well. The city has provided no legitimate, content-neutral justification for the application of this ordinance to this defendant's conduct that would survive scrutiny. The charge is dismissed. I looked up from the bench when I finished reading. The room was quiet. Not the kind of quiet that comes from shock, the kind of quiet that comes when something has been named correctly, and the room is adjusting to the fact of it having been named. I noticed in my peripheral vision that one of the 3 city council members seated in the gallery had stood up and was moving toward the door. I do not know whether they intended to leave before I had finished. They did leave before I had finished. I continued reading. What the city called a permit violation, I called by its actual name. And names in a courtroom have consequences. I want to say something about that sentence because I believe it is true in a way that extends beyond this case, and because I came to understand it with particular clarity that morning. The permitting system is not inherently a weapon. It exists for legitimate reasons, and it serves legitimate purposes. And most of the time, the people who administer it are doing so in good faith. But a permitting system, like any regulatory mechanism, can be used. It can be pointed. And when it is pointed at a 75-year-old man feeding hungry people on a sidewalk, on behalf of business owners who would prefer not to look at the people being fed, then the thing that is in front of me is no longer a permitting dispute. It is something that has a different name. And my job, the specific non-delegable job I took an oath to do, is to give it that name on the record. He had 11 years of Saturday mornings behind him. The city had one ordinance. I had the Constitution. That was the accounting in that room. And I want to be honest about what that accounting produced and what it required of me to reach it. What it required was not courage. I want to be careful about using that word. What it required was attention. The specific attention of someone who reads the legislative history, who asks the question 3 times, who looks at the photograph on the evidence table and understands that what is in it is the case, the full case, not the legal abstraction, the people. I asked Reverend Leonard when the ruling had been read into the record if he had anything he wanted to say. He said, "I am grateful." Then he said, "I am planning to set up my table this Saturday." He asked if that would now be permitted. I told him that question was between him and his conscience, and that this court had found his conscience to be in good standing. He smiled. It was not a triumphant smile. It was the smile of someone returning to something they had never truly left. I have been in my courtroom for 4 years. I have seen many different kinds of relief on many different kinds of faces. What I saw on his face that morning was not relief at winning. It was the simpler satisfaction of having been seen correctly. I thought about that smile for a long time after the proceeding ended. I am telling you this case because I believe it demonstrates something that I think matters for everyone watching. Not as a legal lesson and not as a commentary on how cities use their regulatory power, though both of those things are present in it. I am telling you this case because of what it asks of the people who are not in that courtroom. There is someone in your life, I am reasonably confident of this, who is doing something decent, quietly, without recognition, and doing it in the face of some form of institutional resistance. Not necessarily legal resistance, a bureaucratic obstacle, a process that exists to wear them down, a requirement that applies to them and not to others. You know the person I am describing because you have watched them navigate it. And what most of us do most of the time when we see someone we know navigating that kind of resistance is we express sympathy and we move on because we have decided that there is nothing we can do about it, that it is their problem, that we are not the ones with the authority to address it. What I want to offer you, not as a judge, but as a person who spent 5 years as a public defender, watching what happens when people stand alongside those who are being pressed down by a system that assumes they will simply give way, is this. The presence of a witness changes what is possible. Reverend Leonard's case reached my courtroom in part because people showed up, his congregants, people from the neighborhood who had eaten his soup. They wrote letters. They testified. They were in the gallery that morning, not in a dramatic way, in the ordinary way of people who had decided that what was happening was worth showing up for. You do not need to be a judge to do that. You need to decide that the person being pressed down is worth your presence. That is the thing this case gave me. That is the thing I am asking you to give someone. If this case meant something to you, if what I described in that courtroom resonated with something you have felt, or something you have watched, or something that is happening right now in a situation you know about, I want to hear from you. Tell me in the comments what you saw when you listened to this. Tell me about the person in your life who is doing something decent and meeting resistance for it. Tell me what it would mean for them to know that someone was watching. I read everything. If what I bring to this channel is something you want to keep hearing, the honest account of what goes on inside those rooms, what the decisions require, what they cost, and why they were right, subscribe, hit the bell. What I offer here is not commentary. It is not legal analysis. It is what I saw, what I decided, and what I am still carrying from it. I want to end with this. Reverend Leonard set up his folding table that Saturday. I know this because his attorney sent a brief note to the court the following week. Not a legal filing, a note, one sentence. It said, he was there at 7 in the morning and he stayed until the soup was gone. I kept that note. That is the case. That is what it took. That is what the job is for.